start the recording now, and then let's start so that we don't use up any more of your time. I don't
So I
want your
won't be
battery to
disturbed
run
while I'm
out.
talking. As I said, I'm not used to. Oh, yeah. Sure.
Okay.
Yeah, not a problem. It's the maximum, so it's not another problem.
Okay. Good afternoon, everyone who is in the
I like
room. Thank you so much for attending this session. As you would know, every Thursday we have a seminar or a presentation or talk that is brought to you by the Transformation Office as part of its Equality Promotion and Social Inclusion project. And here we really want to focus on human rights and specifically the right to equality and addressing some of the contentious issues that affect the full realization of human rights. Today, we have a very esteemed academic that is going to give us a presentation, Dr. Cristiano Dossi. I'm going to read his biography, and from there I'll hand over to him to start with his presentation. The title of his talk today is LGBTIQ plus communities in Africa, protection of rights or abuse of persons. Dr. Cristiano Dossi is a senior research fellow and a researcher at the South African Research Chair in international law in the Faculty of Law at the University of Johannesburg. He holds a BA honors equivalent in international relations, as well as a master's degree in diplomatic studies from the Italian Society for International Organization in Rome. He has a master's advanced studies equivalent in international relations, specifically international law, from the Graduate Institute for International and Development Studies in Geneva. He also holds a PhD in international relations, specifically international law, from the same institution. And he has done his postdoctoral studies at the University of Michigan Law School and at the Center for Human Rights and the University of Pretoria. His research interests mainly focus on the legal protection of asylum seekers, refugees, migrants, as well as IDPs in Africa, as well as African human rights law, and more broadly, the development of public international law in Africa. So his expertise are very, very broad, and he's the right person to be speaking to us today. So we hand over to you, Doc. Please take it away.
Okay. So thank you so much. Can you hear me? Yes. Thank you so much, Adelaide, and the Nelson Mandela University for the invitation. Today, I will try to talk a bit about the situation of LGBTIQ plus community in Africa, also at what happens to them during the pandemic, and I will also conclude my presentation with a case study of what happens in the newest country in Africa, I mean in South Sudan, what is the protection of the LGBTQ plus community. First of all, we have to define the concept. According to the Office of the High Commissioner for Human Rights, that is based in Geneva, the OHCHR, the lesbian, gay, bisexual, transsexual, intersex, and queer persons are particularly vulnerable in Africa. In fact, in the acronym, the Q can be interpreted in two ways, because Q can stand for queer, but Q stands also for questioning. It means person who has not decided yet which is their sexual orientation and their gender identity. So the Q, in fact, it would be more correct to put two Qs, but the Q has two meanings, in fact. While the LGBTIQ plus terms of, and the plus, of course, stands for all the other categories that are not really comprised in this acronym. The other categories of persons who have, who still are not part of this acronym, whose gender identity used to describe people who are attracted to persons of the same sex and those who have non-binary gender identities. For example, I put several examples. In Gumo, in South Africa, they are called Skesana. In Lesotho, in Sesotho, they are called Motsoale. I don't know the pronunciation though, but I hope that you can understand. While in Swahili, they are called Kuchu, and in this term of Kuchu in Swahili is increasingly used by the Ugandan LGBTIQ plus community. Hence, it's important to use and respect the term that people use to refer to themselves. So the existence of this local word, it means that historically, this category of persons were recognized in this country, even before they became independent, but they were recognized in those communities. This is very important because it seems that, and we'll see this after this concept after, it seems that this category have been imported from Europe, but no. I mean, homosexual people with non-binary gender identities is not a product of culture, it's a product of nature. That should be, I mean, it should be quite clear. So they always been existed in Africa like elsewhere in the world. The problem was that they were discriminated, they probably are still discriminated a bit everywhere, but they've always been existing. Of course, during the pandemic, it's clear that the COVID-19 pandemic has deepened and exposed the human rights violation to which this population were already subjected. However, the impact of the pandemic on LGBTIQ plus communities has been glaringly absent from most media coverage. African queer peoples already experience a unique set of violence and oppression, often in silence and with virtually no societal and governmental sympathy. Unsurprisingly, the COVID-19 pandemic has exacerbated the human rights plight of queer people in various African countries to dangerous new level of isolation, stigma, abuse, and violence. Prior to the COVID-19 pandemic, the LGBTIQ plus community in Africa already faced high levels of violence. 28 sub-Saharan countries in Africa, 28 out of 53, so it means more than the half, still criminalize consensual same-sex conduct, an enduring relic of colonialism. And such laws are used as a justification to assault, ostracize, demonize, and discriminate against LGBTIQ plus people. During the time of crisis, the LGBTIQ plus community is an easy scapegoat to justify also bad fortune. For decades, for example, queer communities in various African countries, including Liberia, Nigeria, Senegal, and Uganda, have been blaming for bringing bad luck to their nation as God's revenge for their homosexuality. In April 2020, in a joint statement, UNAIDS, that is the UN agency that takes care of the AIDS disease, and an NGO called Impact Global Action for Gay Men's Health and Rights, expressed extreme concern about queer people being blamed and abused in Africa and urged government to protect their human rights. Law enforcement across many African countries provides no avenue for protection for them, for the LGBTIQ persons, as the police are often notorious for facilitating state-based harassment of queer people under the guise of enforcing criminal laws sanctioning same-sex relations. New emergency powers, which many states have adopted and enforced to respond to the COVID-19 pandemic, have only intensified state abuse of queer Africans. Uganda, as I mentioned also before, for example, graphically illustrated the willingness to abuse its LGBTIQ plus community early on in this pandemic. In fact, on 29 March 2020, shortly after the lockdown began, the Ugandan police used the pandemic as a cover to target LGBTIQ people by raiding the Children of the Sun Foundation, an LGBTIQ homeless shelter near Kampala. The police, army, and even the municipal mayor collectively berated the young men and women for their perceived sexual orientation and gender identity. Video footage of the situation shows the mayor beating the shelter residents with a cane while lambasting them for being homosexual. The police proceeded to arrest and detain 20 homeless residents of the shelter for supposedly committing, I'm quoting, a negligent act likely to spread disease or infection due to the living in the shelter. While tied together, the group was publicly marched to the police station and then denied their right to legal representation when officials refused their lawyers physical or telephonic access to their clients. Again, expert fear that Uganda was using, in fact, COVID-19 emergency powers to target the LGBTIQ people. On the 27th April 2020, in Geneva, the UN experts were alarmed that Uganda could be using COVID-19 emergency laws to target gay, lesbian, bisexual, and transgender people, and urged the government to strictly limit the use of emergency power to public health issues. What they say, the human rights expert in this statement, I'm quoting them: "We are deeply concerned about a raid on the LGBTIQ plus shelter in Kengera on 29 March 2020 and the arrest and detention of 19 people perceived to be LGBTIQ plus persons." The group of experts said that they had been told local authorities raided the shelter based on the perceived sexual orientation or gender identity of the residents, who were then charged for allegedly disobeying coronavirus regulation on physical distancing. It's feared that authorities are not using COVID-19 measures solely for the protection of public health, in fact. Not by chance, what they said, what they added, these experts in Geneva, on the situation of LGBTIQ plus people in Uganda. I'm quoting them: "Emergency powers to combat crises such as COVID-19 derive their strength and legitimacy from strict adherence to their object and purpose. Any emergency response to COVID-19 must be proportionate, necessary, and non-discriminatory. When authorities use emergency powers for different purposes, they are acting arbitrarily. In this case, in the case of the Ugandan LGBTIQ plus people, we are concerned about a possible violation of the prohibition of arbitrary detention. Using COVID-19 emergency powers for other purposes, such as targeting particular groups under the guise of protecting health, jeopardize the whole response system. Abuses must be prevented, investigated, and punished to safeguard the common good." The expert also highlighted concern that the detainees in this case allegedly have no access to their lawyer due to the COVID-19 measure and are being exposed to a greater risk of violence and discrimination because of the actual or perceived sexual orientation or gender identity. For more than 40 days, the queer detainees were denied bail and access to their lawyers while detaining in crowded conditions. So you see on one side they were arrested under the allegedly situation of violation of the COVID-19 measures, but afterwards they were detained in prison in crowded conditions. So you can see the the contradiction. There were complaints that while in detention, they also were subjected to torture. The prosecutor in Kampala finally dropped the charge, and the magistrate court ordered the release of the group on 18 May 2020. The acts of the Ugandan state violated numerous human rights protection guaranteed under the ICCPR and the Banjul Charter, the African Charter of Human People Rights, as well as the Ugandan Constitution, to be free from discrimination, arbitrary arrest and detention, and cruelly inhuman and degrading treatment. This was such a blatant targeting of Uganda's LGBTIQ population that the UN Working Group on Arbitrary Detention and the UN independent expert issued a joint statement expressing serious concern about the authorities' abuse of emergency power to persecute queer people and urging them to release the detainees. While in certain circumstances, international human rights law allows for some rights to be limited, like many other purported COVID-19 response measures implemented in relation to LGBTIQ persons, Uganda's raid of the shelter did not meet the standard of serving the legitimate aim of protecting public health, and the ensuing deprivation of liberty was disproportionate and seemingly not in pursuit of any specific public health interest. Human rights lawyers from a Ugandan LGBTIQ+ advocacy organization, the Human Rights Awareness and Promotion Forum, it was shortened HRAPF, represented the queer young homeless individuals in litigation to vindicate their infringed rights. In June 2020, the High Court of Uganda affirmed that the state violated the arrested group's constitutional right to liberty and right to a fair trial by denying access to their legal representatives, for which each detainee was awarded damages. The HRAPF and the concerned LGBTIQ people continue to pursue accountability in domestic fora for the human rights abuse they endured during lockdown. Always in July 2020, they also filed a suit in the Uganda High Court seeking redress against the action of torture, inhuman and degrading treatment, discrimination, and violation of privacy perpetrated by the mayor and the prison officials. In the judgment that was released on 15 June 2020, the High Court in Kampala observed that the right to a fair hearing could not be waived even during the COVID-19 crisis, since the right, I'm quoting the court, is inalienable whatever the circumstances. The court further observed that the Chief Justice issued guidelines for certificate of urgency, as well as taking pleas and bail application during the COVID-19 lockdown, something that showed that lawyers had to have access to their clients if these matters were to be heard. The prison authorities could therefore not deny lawyers access to their detained clients using the excuse of COVID-19. The court referred to the interim guidance issued by the Office of High Commissioner of Human Rights and the World Health Organization in March 2020 that emphasized the measure taken to prevent COVID-19 outbreaks in the detention center must respect human rights, and the ability to meet with legal counsel must be maintained. On the rights to liberty, the High Court in Kampala observed that although the right could be limited, there were many options available to prison authorities to allow lawyers to access their client without putting people at risk of contracting COVID-19. Denying the accused person access to their lawyers for 40 days, the court said that it was unreasonable and unjustifiable. Queer African communities are not only at increased risk of state abuse during the pandemic, but also of a surge of private acts of violence during stay-at-home orders. With the onset of lockdowns, African LGBTIQ+ persons abruptly lost access to the safe havens they created for themselves: a community center, nightclubs, cafes, NGOs, and universities, as this space closed physical operation and university students had to vacate campus to return home. However, home is rarely a refuge for queer individuals in Africa, as family and or local community rejection and abuse are commonplace. The director of the Gays and Lesbian Association of Zimbabwe, for example, lamented that mental health challenges had increased during the pandemic, and the queer community had been left more vulnerable since the closure of drop-in centers, which provided psychological and recreational services. With the abrupt disappearance of social networks, a queer Kenyan woman, as another example, reported that, I'm quoting her, "It feels like we are all just struggling to stay alive." Increasing mental health breakdowns and suicide attempts with little to no recourse or support have been a global trend for LGBTIQ+ persons during lockdowns. Isolation in close quarters with often unaccepting family members has exacerbated queer people's anxiety, triggering painful memories and depression, hopelessness, and suicidal ideation. For example, the advocacy offer for Outright Namibia, that is another organization in Namibia for the protection of the queer human rights, reported that the organization health and wellness officer has been inundated with calls during the lockdown, especially from people feeling suicidal. While the pandemic-induced increasing violence against women has received international attention, the domestic and community abuse that queer people experience is largely invisible in the media, as I also mentioned before. Abused LGBTIQ persons in Africa are commonly denied protection or recourse due to hostile attitudes of law enforcement. Historically, state could not be held responsible for the act of non-state actors under international human rights law, and thus domestic and community abuse of queer people was beyond the realm of state concern. Yet, during the last 30 years, developments in international human rights law have established that states have a positive human rights duty to act with due diligence to allow all people to live free of violence. The African Commission on Human and People Rights has affirmed in a communication of 2002 that Zimbabwean Human Rights NGO Forum versus Zimbabwe affirmed that the due diligence principle by which a state may be held responsible for the violence committed by private person, I'm quoting the commission, due to its lack of due diligence to prevent the violation or for not taking the necessary step to provide the victims with reparation. So also the African Commission recognized the role of the state when it comes to the violence of vulnerable people, so queer individuals included. Prior to the COVID-19 pandemic, African states were already notoriously violating the due diligence principle in relation to the violence meted out against queer people. The pandemic has, of course, exacerbated this private abuse. For example, I took the example of a South African homeless called Tembi, who was a trans woman sex worker in Cape Town, was rounded up with hundreds of other homeless individuals and forced to stay in a temporary government shelter during lockdown. There, Tembi faced daily transphobic verbal abuse from fellow residents. Eventually, the verbal abuse escalated into a physical attack on Tembi while the security staff simply looked on. The Kenyan LGBTIQ activists have also similarly spoken out about a substantial increase in attacks on queer Kenyans since the start of the lockdown, with the Gay and Lesbian Coalition of Kenya receiving reports of at least 10 attacks against queer people per month. From Zimbabwe to Kenya, LGBTIQ advocates are documenting and raising awareness about the increased human rights abuses occurring during the pandemic. But the onus to protect this marginalized population does not and should not fall solely on the shoulder of human rights activists, of course. By intervening to hold the state accountable for such violation, the Ugandan High Court in 2020, in the case that we just saw, unequivocally upheld the universality of human rights protection, regardless of sexual orientation and gender identity. However, not all the victims of state and private abuse have access to litigation or judicial redress. Regional human rights mechanisms, particularly the African Commission, should use this opportunity to call for the explicit protection of African queer communities, further elaborate on the legal obligation of its member state, and finally adjudicate a sexual orientation, gender identity case in order to set a strong precedent for the continent and beyond. I'm mentioning now the resolution from the African Commission, the number 275 of 2014. This resolution, number 275 of 2014, it was entitled the Resolution on Protection Against Violence and Other Human Rights Violation against persons on the basis of their real or imputed sexual orientation or gender identity, was adopted in line with the Commission mandate to interpret the rights enshrined in the Banjul Charter. Resolution number 2075 expresses grave concern about increasing violence and other human rights violations, including murder, rape, assault, in respect of persons based on their real or perceived sexual orientation or gender identity. It stresses the worrying nature of such violence, whether committed by state or non-state actors. This resolution calls upon states to take action for stopping such violence, to ensure that human rights defenders working on the human rights of sexual minorities are free from reprisal, and take appropriate measures to ensure adequate remedies are ensured to victims of such violence. Having given a bit of a general panorama, I would like now to speak a bit. I just took, as I mentioned before, a case study. What happened in South Sudan? Why was South Sudan? Simply because it's it's the newest African sovereign state. So, in principle, it should also consider a bit progressive, though we will see that it's not really the case. South Sudan is the newest universally recognized country internationally, which declared independence on 9 July 2011. Born from the ashes of a conflict with its northern neighbor of Sudan, South Sudan initially made enormous strides given the goodwill of its people and the international community that wanted it to succeed. However, its post-independence history has not been peaceful, with its governance that has been defined often as I'm quoting, kleptocracy. Against this backdrop, since 2012, its first full year of independence, human rights violations recorded in South Sudan were massive. The following civil war did not improve the situation of respect of human rights in the country. Yet, in this framework, it's not surprising to ascertain the treatment often reserved to LGBTIQ+ persons. South Sudan is a predominantly Christian country, where the highly revered religious leaders many times have publicly stated that marriage should be strictly between men and women. When the topic of same-sex relationships has attracted public discussion, Christian leaders in South Sudan have simply denounced it as a perversion. Homophobic discrimination seems to be worrying above all in the Episcopal Church. This religious stance finds a strong supporter in President Salva Kiir Mayardit that even before independence in 2010, affirmed that LGBTIQ plus recognition is not in the character of South Sudanese people. He also added that homosexuality does not exist in South Sudan, and if anybody wants to export it to South Sudan, this action, I'm quoting him, will always be condemned by everybody. Before him, back in 2004, Aleu Akejak Jok was an appellate court judge from South Sudan that was still part of Sudan, affirmed that in South Sudan, if men are found guilty of having consensual sex with another man, they will be killed by firing squads. In spite of this, ethnographic studies have proved that in ancient times, the practice of having, for example, female husbands was widely accepted among the newer, where Zandi people, both men and women, engaged in same-sex relation without any major problem. Nuer and Zande are two of the largest ethnic groups in South Sudan. The evidence ranged from chiefs engaging in sexual relations with youth who were considered disease-free to the general acceptance of same-sex engagement. In 2012, Sudan's first online gay magazine named Rainbow Sudan became available. This primarily points out the situation within the Republic of Sudan, but occasionally refers also to LGBTIQ issues in South Sudan as well. Yet, contemporary times present an all too different story. In 2008, the autonomous government of South Sudan, or still part of Sudan at that time, adopted its own penal code, which prohibits carnal intercourse against the order of nature, punishable with a fine and sentence not exceeding 10 years detention if there is consent, and not exceeding 14 years if consent is absent. This is section 248 of the Penal Code of South Sudan. The title is Unnatural Offenses. Section 249, Acts of Gross Indecency, is also significant to outlaw LGBTIQ plus individuals, as well as Section 379E, criminalizing, I'm quoting, any male person who dresses or is attired in the fashion of a woman. This last section can be used above all to target transgender persons. To mitigate this sanction, according to the Code of Criminal Procedure Act, a person accused of an offense punishable with imprisonment for a term not exceeding 10 years can be released on bail. Along the same line of the Penal Code, the 2011 Passport and Immigration Act of South Sudan, Section 15(5), states that the visa to enter South Sudan shall not be granted to an alien who, I'm quoting, is responsibly suspected to be entering South Sudan for the purposes of prostitution, human trafficking, but also homosexuality and lesbianism. It's quite interesting to note that, homosexuality is a neutral word, but for South Sudanese Passport Immigration Act, homosexuality is only seen among men, because in fact, he adopted the term homosexuality, but he also adopted the term of lesbianism, referred, of course, to homosexual women. So you also can see the confusion that sometimes government make, because they're not even really clear the definition and the basic concept concerning LGBTIQ plus people. The 2011 Constitution of South Sudan is also clear in promoting solely heterosexual relations. Article 15, right to found a family, concedes that in the country there is a right to marry exclusively, I'm quoting, a person of the opposite sex and to found a family. Consistently with this provision, when during the United Nations Universal Periodic Review, Uruguay recommended to repeal the Penal Code provision criminalizing sexual relation between consented adults of the same sex, the South Sudanese government simply responded that the recommendation was, I'm quoting, in conflict with South Sudan customs and belief, as such cannot be supported. In 2017, the US Department of State Country Report on Human Rights for South Sudan found that there had been no information of the authorities enforcing the restrictive laws in recent years. Nevertheless, for example, in the 2020 edition of the same document, LGBTIQ plus persons reported security forces regularly harassed and sometimes detained, tortured, and beaten. Because of actively hostile government rhetoric and action, most openly LGBTIQ plus citizens fled or are fleeing the South Sudan. Yet many of them have fled to Kenya and relocated in Kakuma refugee camp, where unfortunately they are still attacked also there. In this unfavorable scenario for LGBTIQ plus communities, South Sudan is also assisted by the fact that the three sub-regional organizations it's part of have been until now completely silent on the subject of the homo-trans intersexuality. For example, the Common Market for Eastern and Southern Africa, the COMESA, South Sudan joined in May 2006, the IGAD, which played an important role in the peace talk during the civil war in the country, and the East African community never have adopted any document dealing with the situation of the LGBTIQ plus communities in the area. As I mentioned before, the African Commission adopted the Resolution 275 in 2014, condemning violence based on sexual orientation and gender identity. The resolution, I'm quoting, call on state parties to ensure that human rights defenders were able to work in an environment free from stigma, reprisals, or criminal prosecution as a result of their human rights protection activities. In addition, states were urged to no longer tolerate acts of violence and abuse by adopting laws to prohibit and punish this form of violence directly toward people because of their sexual orientation and gender identity. States were also advised to investigate and prosecute perpetrators of violence and have the necessary judicial means to support victims. Useless to add that this resolution remains a dead letter in South Sudan because the limits of the African human rights body are evident in how member states default on implementing its decision. The interesting thing is that by this time, instead of the African Union positive influencing state in dealing with LGBTIQ plus matters in a more progressive way, the AU seemed to take retrograde steps. The African Commission granted, for example, the African Commission granted observer status to the Coalition of African Lesbians in May 2015. However, at the 2018 Addis Ababa Summit, the AU Executive Council was concerned about the non-implementation of its decision of June 2015 on the withdrawal of the observer status of the Coalition of African Lesbians and requested the African Commission to comply with that decision. So the African Commission finally stripped the Coalition of African Lesbians of its observer status on August 8, 2018, because the Coalition of African Lesbians was, I'm quoting the African Commission, was attempting to impose values contrary to the African values. In June 2018, the AU Executive Council requested that the African Commission would withdraw the accreditation of the Coalition of African Lesbians by the 31st December 2018 at the latest. At first, the African Commission tried to resist to the pressure received by the Executive Council, above all scrutinizing the notion of African values within the framework of its mandate to interpret the African Charter. But it was finally obliged to yield to pressures. This decision, and I'm done, this decision revived the debates around homosexuality in Africa. Because by referring to African values and tradition, the AU Executive Council seemed to put emphasis on the idea that homosexuality is an import from the West that goes against African tradition, although we have seen that this idea is historically not true. In converse, evidence suggests that it was the historical processes of colonization and missionarization which regularly altered African sexual practice, including same-sex relations. So instead, while African say that it was not in the African tradition, in fact, it seems that really was the West, the colonizer, that really brought this idea in Africa that homosexuality is not good. It's something to be condemned. It is not really something belonging historically, ethnographically. It does not seem something belonging to Africa, but is more a product of the religious missionary who came from Europe to civilize Africa. As such, it cannot be a surprise to find out that LGBTI communities are struggling to affirm their status and their rights in South Sudan, like in many other African countries. Thank you so much for your attention, and of course, I'm open to any comments or questions.
Okay, thank you
Yes.
so much, Cristiano, for that amazing presentation. We do have a few questions in the chat. I just want to let you know that we're also live on Facebook. I thought about that quite late.
Yes, I saw it. Thank you so much.
I just put that on now as well. At least those that are watching will at least watch the question session. But we have a question there from Piwe Gonzo that says, thank you so much for the awareness. I sit and wonder, what is the International Court or Parliament of Africa doing about such violent, inhumane practices by these countries? I think that ties in a bit with the next question that says,
Oops. Sorry, I lost you.
are you still with me there?
Now I'm listening. I lost you for several seconds. Sorry.
Okay, so should I repeat the first question again?
Yes, please. Yes, please, if you can. Yes.
Okay.
Because I couldn't hear you properly. Excuse me.
Okay, so the first question says, thank you so much for the awareness. I sit and wonder, what is the International Court or Parliament of Africa doing about such violent and inhumane practices by these countries? And then the next question says, what can be done to further expose these vast violations of the LGBTI plus human rights in these African countries? And how can international human rights organizations actively intervene to ensure that the LGBTI plus human rights are adequately protected? The next question there then says, what does this degrading and poor treatment of the LGBTI community in this country not also amount to hate crimes? And then the last question says, for African countries where LGBTI plus community rights are protected, are they afforded protection in the actual sense, or are these just formal rights which are not fully realized? So are they just rights on paper, but when we look at reality, are these rights being fully realized? I think you spoke a bit about that when you said some of the atrocities against the LGBTI plus community are not actually broadcasted on the media and so forth. So I think those are some interesting questions there. I think maybe just to add my own, is that you mentioned in the beginning that if we look at it in the indigenous community, we actually had terms or words to express the LGBTI community, which means there was an acceptance or tolerance. at what stage do you think that tolerance or acceptance fizzled out, and what are some of the factors that you think had a play in that? Do you think maybe colonization had its role in that, where this now became a westernized concept, or what really do you think happened there? So those are our questions. Please do take it away there.
Yeah, sure. I'm trying to summarize all of them. And if I forget something to respond to, please afterwards you can remind me. And well, I'm responding you from the end, from yours. As I said, there is all the studies that have been done. As I also mentioned at the end of my presentation, all the known studies done on the homosexuality, on the treatment of homosexuality in Africa, shows this dichotomy. Because if you want, also in this, unfortunately, Africa is a bit behind, because many African governments, they say that, as I mentioned before, that homosexuality has been imported from Europe. But this is not true, as I said. The idea that homosexuality was a practice to condemn, first came to Europe, in fact. It came to Europe because, and not only to Europe, but also from the Gulf, because all the revealed religion, I mean, Christianity, Islam, and Hebraism. But okay, Judaism doesn't spread a lot in Africa, but Christianism and Islam, yes, both of them, they heavily condemn homosexuality per se, and acts of homosexuality. So of course, during the period of the missionarization of Africa, of course, this message that the homosexuality is something that is natural, it needs to be condemned, was introduced in Africa by both the missionary of these two religions. But what happened afterwards? So it was infused in the African mentality, this. Although I made the example of South Sudan, but the example everywhere, I mean, in all the region in Africa, where naturally, before the presence of the colonization, of the colonizer, of not even the colonizer, but the missionary, these practices were widely accepted everywhere in Africa. The problem now, what was it? Then now, although both this religion, formally, they still keep a strong condemnation of homosexuality, above all, in the West, practice show more tolerance. But so this more tolerance, that is very recent, because it's very recent, is seen now in Africa as something that in fact is unnatural. But it's not the tolerance that is natural for Africans. The tolerance, it is what really was at the beginning, in the history of Africa, the tolerance was applied to homosexuals. What is unnatural has been the pressurization and the condemnation of these communities. But they were so infused, the African communities now and the government, that now they see the tolerance as something, it's a bad product of Europe. But it's not. The bad product of Europe for homosexual in Africa was the lack of tolerance, the first came with missionary. But unfortunately, the African government, many African communities didn't take this additional step to say, okay, but let's see what happened before the missionary. Let's see what happened in